Hey everyone, this is Stephen Demopoulos once again. I am the owner of Highview Law, a probate and estate planning law firm in Los Angeles. Today I'll be talking about what is letters in probate. But before I do that, if you have any questions about probate or estate planning matters and you'd like to set up a call with me for free, you can go to estate-meeting.com. That's estate-meeting.com. So what is letters in probate? Often people who are the heirs of an estate, their first encounter with the probate process is they come across this term letters. They might try to get access to accounts that they are the heirs of, or try to get access to real estate that they're entitled to, and they're told that they need to get letters first. So this is a question that I'm often asked. What is letters? So in a nutshell, essentially, letters is court-granted authority given to someone to deal with the estate of someone who's passed away. So essentially, the court gives authority to someone, and that person has the authority then to deal with everything that needs to be done with the estate, to pay off creditors, to pay taxes, to do everything in order to ultimately get the assets to the rightful heirs of an estate. And because lawyers like to make things very complicated, there are two kinds of letters. One is if there is a will, it's called letters testamentary. If there is no will, it's called letters of administration. And to make things even more complicated, if there is a will, the person who gets letters is called the personal representative. If there's no will, the person is called the executor. So either the personal representative or the executor has to get authority from the court to get the work done of administering an estate. There's a source of confusion when there is a will, because a will lists a personal representative. And so often people will think that when the person whose will it is dies, then the personal representative listed in the will has immediate authority to start getting stuff done. But that's not the case. What has to happen first is the court needs to be petitioned, the will needs to be turned into the court, and then the court has to grant official authority to that person to become the personal representative. That person signs an oath, and that person then gets a certified copy that shows that that person is actually the personal representative and has letters testamentary, so that then that person can do the work that needs to be done. If there's no will, the executor, the person who gets letters when there's no will, is chosen usually by the heirs. If the heirs can't choose someone, then a judge is going to choose. But ultimately, it's the same process. That person gets a certified piece of paper that states that that person has letters. Then that person can start doing the work. So hopefully that clears up some confusion about what letters actually means. If you have any probate-related questions, want to talk about things I've talked about today, any estate planning questions, you can set up a call with me for free at estate-meeting.com. That's estate-meeting.com. Thanks for listening.